start by distinguishing between an estate planning lawyer and an elder law attorney, because most people are confused as to who does what. Estate planners help you figure out how to distribute your assets after you die. Elder law attorneys put the structure in place so you can have the resources you need as you meet the challenges of aging, and both financial resources and personal resources. And we're all going to have the challenges of aging. I keep looking for loopholes, and I haven't found them yet, and if I ever do, believe me, I will let everybody know. Financially, honestly, we don't do this very well as a nation. We really don't. We favor long-term care in institutions, just as a culture, and legally we tend to favor nursing homes. There are more incentives for people to go into nursing homes than to get services at home. We're working on changing it. Change is coming painfully slowly. There is something called the waiver program, which does let you have some services at home. It's not automatic. There's a waiting list. You're just starting to take people off the waiting list. And you wait for, what is it again, Jennifer? 8 years, 5 years, 4 years? And they're just going to take people off now. So it's there, it's coming, but for now, if you really need serious care, you're looking at a nursing home. Nursing homes tend to cost roughly $100,000 a year, just about. Medicare doesn't cover it. You're really just looking at either long-term care insurance, if possible, which will cover some of it. But if you really need a long-term care, then you're looking at government programs, and that would be Medicaid. And elder law attorneys can help you structure your assets so you qualify for government benefits without going bankrupt yourself or bankrupting your family. So please, 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 if you're facing any kind of long-term care, see an elder law attorney before you do anything, even just for a consult. The other thing we do also is put the structure in place for decisions to be made when you're no longer able to make them yourself. Again, financially and healthcare. I'm going to talk a little bit about financial. What you need to do is, and everybody does need to have it, is a financial durable power of attorney. It doesn't do anybody any good if you've got a $300,000 IRA sitting there and you need long-term care, you need assisted living, and nobody can access that because no one has a power of attorney over your assets. If you have that kind of situation, what's going to happen is somebody's going to be forced to go into court, get a guardianship, which is going to cost thousands of dollars, literally. It's going to take several months to do. In the meantime, somebody's going to have to be paying that long-term care bill on their own until they can actually get access to your money. So save everybody the headache and spend a few $100s and get a financial durable power of attorney. They can then immediately, you need the help, they can immediately just turn it over to Fidelity or whoever's got the IRA. Fidelity says, okay, you've got it, and the check starts flowing. So it's very easy. It's an ounce of prevention is worth a pound of cure. What I do want to spend some time on tonight, though, is healthcare decisions, especially in light when my father started all this and where we're likely to go as a country, especially when we're talking about physician-assisted suicide and all that stuff that might be coming down the pike. As long as you are competent, you have absolute authority over who does what to you, what kind of medical care you get, what kind of medical care you refuse. No one can touch you without your consent. What happens when you don't have that capacity? What happens if you've had a stroke? What happens if you have dementia? What happens if you're in an accident, you're in a coma? Who's going to make those decisions for you? I would, hopefully, you would have planned in advance and you would have executed a healthcare power of attorney. And that means you've decided who it is that's going to be making those decisions on your behalf. You write that down. You say, oh yeah, my cousin Joe, he's known me since since I was born. We grew up together. He knows me better than anybody else. He knows exactly what I would want to do in this situation. Cousin Joe is the first person on my list. And if my healthcare provider can't get a hold of Cousin Joe, I want my Aunt Mary. And if they can't get a hold of Aunt Mary, then I want Uncle Fred. You put down exactly how you want, who you want to make those decisions for you. And it's in a written piece of paper, it's witnessed by two people, and everybody has it, there are no questions. What happens if you don't have a healthcare power of attorney? and decisions need to be made. Well, the law has stepped up and they created a hierarchy for us. So the first person that gets to make the decision is your court-appointed guardian, which, as I've already said, is a long, drawn-out process, and you ultimately don't know who's going to be appointed as your guardian. Next in line is your spouse or your domestic partner. Then comes adult child, parent, adult sibling, and none of them work, then a friend or other relative who can establish that, yes, they have that relationship to you, and yes, they can also document that they've known you for a long time and they know your values and beliefs, and they are the person who is capable of making those decisions. But that's it. So, without you naming who it's going to be, you've got this hierarchy of people, and you may not want your neighbor Jane to make those decisions for you, but she may be the only one around. Now, then again, in the event you don't have all that laid out in advance, what happens is the petition for the guardianship. And I want to talk a little bit about what that means, because it's for both financial and personal. What happens is somebody's going to have to petition the court to appoint a guardian. The court then appoints an attorney to represent your interest as the proposed ward, and basically does an investigation, reports back to the court as to whether or not you do or don't need a guardian, and to who would be best suited to serve as guardian. If it's uncontested, it's pretty much where it stops and starts. Everybody goes to court, the court says that's fine, gives its blessing, and whoever petitioned the court to be appointed as guardian becomes appointed as guardian. If someone disagrees, then it becomes a contested guardianship. All of a sudden, you go from spending $5,000 or $6,000 in attorney's fees to about $15,000 or $20,000 in attorney's fees. All of this can be avoided by simply executing a healthcare power of attorney and a financial durable power of attorney. Another thing with the surrogate decision makers, particularly in the light of healthcare, is in the event we do come up with something like physician-assisted suicide, what's going to be the role? And you're incompetent. Is your surrogate going to be able to make that decision and have a physician go ahead and do that to you or for you, or however you look at it? Up until now, all of the physician-assisted suicide laws have kind of been limited to only people who are competent to make those decisions for themselves. However, it was only 2 or 3 years ago in Maryland that we had a proposed bill out for organ donation for people who were in persistent vegetative state. And we came this close. And the Catholic Church was instrumental in getting rid of that. And persistent vegetative state means you are in a permanent coma. And it means someone else is making the decision that the doctors could take your body parts and give them to whomever. And I don't know if anybody remembers the book by Robin Cook, Coma. Yeah. But it just had visions of that where, they kind of keep these bodies, and that's what they would do, is they would keep the body in a persistent vegetative state, and they would just harvest the organs as they needed until your body couldn't take it anymore. Okay. And we really did come this close to having a surrogate be able to make that decision for you. So I really do urge having a power of attorney. And when you do see your elder law attorney to have that done, make sure that they say, my agent does not have the authority to consent to any assisted suicide or euthanasia in the event the law allows that. Because you don't know what's going to happen down the pike. So I know this isn't always very pleasant to think about, it isn't very pleasant to do, but neither is a colonoscopy. We do them anyway. Find a lawyer. Probably the best way to get a lawyer is through NALA. It's the National Academy of Law Attorneys. There are some brochures in the back that have all the NALA information. You go on the website, you put in your zip code, and you're going to get a whole list of elder law attorneys. So for both financial powers of attorney and the healthcare, police, and elder law attorney, and also for long-term care financing. Because there are ways to do it without breaking the bank. Thank you.